Hi, and good morning to everyone who's joining us today. Maybe good afternoon to those of you who join us from Europe or maybe even Asia. Today, we have a speaker that has been talking on this subject with us at ACSS for many times, and we are very happy to have you back, James, to give us an update on US anti-boycott regulations. I think this is a really timely topic because we've seen, unfortunately, the again the conflict in the Middle East between Israel and Palestine, and this is certainly affecting that region and might affect anti-boycott regulations as well. And that's why we have this update today, not only because of the conflict, but also because of recent updates on the regulations and also the guidance that Commerce BIS published, the resources. So let's just dive right in. We prepared a short presentation for our attendees today who are joining us live on LinkedIn. So we start with the presentation, and at the end, you also have a couple of minutes to ask James your questions if you like. So let's start with the presentation.
Thank you, Alex. All right, today we want to cover a few things. We scheduled this particular update after the annual BIS week. So we'll talk more about that in a minute, but we're going to talk about BIS rulemaking and guidance and memoranda they have issued over the past 2 years. We really want to start on the 16th of May with some comments from Matthew Axelrod, the Assistant Secretary for Export Enforcement at the U.S. Department of Commerce. We'll talk about changes to their websites, which are actually very important. And we're going to give you the links so you can still access the old websites because there's more information there. We'll talk about 6 enforcement actions over the past 18 months or so. And we'll also talk a little bit about the IGO Anti-Boycott Act that was passed by the House of Representatives here in the United States and may or may not be read on the floor of the Senate. So next slide, please. Now, as I said, we're going to start back in May of 2022 because Mr. Axelrod delivered remarks at the Society for International Affairs 2022 Virtual Advanced Conference on Export Controls and International Politics. These comments were talking about their administrative penalties, how they're going to increase the administrative penalties not only on export violations, but on anti-boycott violations. They wanted to evaluate whether the no admit, no deny settlements made in the past would be applicable going forward. And they were looking to roll out these policy changes, not only for the export controls, but also for the anti-boycott violations quickly in a few months. So we'll jump forward to the 6th of October, 2022, and the BIS, the Bureau of Industry and Security, the division of the Department of Commerce that deals with exports of high technology and export controls, and enforces the export administration regulations, amongst other duties. There's a lot of duties in the BIS. The BIS updated its policy for the enforcement of the anti-boycott rules. Note that no rules have changed, but they wanted to ensure that there were enhanced penalties to the classification A, category A violations. But also as a method of deterring future violations, they increased the category B and category C violations. At the same time, they reprioritized those violations. So some things that were B were now C, some things that were C were not B. So the A and B moved back and forth a little bit. But all of that is in their actual regulation, in this memo from in the Federal Register release during the issuance of this memo and this guidance back in October of 2022. And I'm just trying to get through some of the background real quick so we can get to the recent events. They also decided that you had to admit misconduct. There had to be a clear, admittable statement of facts so that there was a factual resolution to what actually happened, that the violations There wasn't any ambiguity, so we could learn from the enforcement. Um, and they renewed their focus on foreign subsidiaries of US companies. So, where the violations, the rules, they traditionally resulted in consequences being imposed on the US partners who received the requests, they wanted to make sure that the issuers of the request, the requestors, were also held accountable. So, this was their plan back in October of 2022. These changes went into effect, and actually, their first enforcement action was on a non-US affiliate of a US company. But let's talk more about the rulemaking. So, in April of 2023, and throughout this time, there were also additional export control memoranda and tri-seal and quad-seal notices with OFAC and with FinCEN, with Department of Justice concerning export controls. But one of the consistent themes was the focus on increasing the number of voluntary self-disclosures, or VSDs, as well as the ability for the BIS and the Office of Anti-Boycott Compliance, OAC, to receive disclosures from parties concerning other parties. So they called it the clarifying policies regarding voluntary self-disclosures and disclosures concerning others memorandum that came out on the 18th of April. And they announced they put together a dual track program for the handling of voluntary self-disclosures. Anything that was a minor or a technical infraction, they were going to fast track that and give you an answer within 60 days. If it wasn't a minor or technical infraction, then it still would end up having a much larger work path through the BIS. There would be the standard requirements for lookbacks. There would be a lot more information requested concerning the violation. Now, the second part was the disclosure about conduct of others. And if a particular party, exporter, freight forwarder, financial institution, were to volunteer information to the BIS that they noticed other parties conducting violations of the anti-boycott regulations, then they would be considered cooperating with the Office of Export Enforcement. And they would have the categorization of exceptional cooperation with the OEE. Now, this concept of cooperation with the OEE is future value. If that particular party were to have violations of their own, that when adjusting or at least addressing the potential fines for those violations, the Office of Export Enforcement, a part of BIS, would take into account if there was this exceptional cooperation with the OEE in assigning the penalties. So we'll put links to all of these memorandas. It's hard to find them sometimes, and that's why we're going to talk about the website, because it's not the same as saying an OFAC notice. All right, so 26th of July, Axelrod announced that they were increasing the amount of information required to submit a report of a request for restrictive trade practices or boycott language, the BIS 621P form. These are filed online or in paper, and as of the 26th of July, they included the name of the requestor and assumed that the country that the origin of the request came from was also the country of the requestor. Now, please note, if you're dealing with trade finance from a financial institution perspective, and you're looking at, say, an MT 700 letter of credit, the requestor is not the issuing bank, the bank that sent the conditions to you as an advising bank or confirming bank. It is actually the name of the applicant, the party that had the issue, had the letter of credit issued. BIS wants to know who is making these requests. And historically, the OAC has talked to foreign governments and foreign financial institutions in order to reduce the amount of requests. And one of their goals was to capture the requester information, as far as I understand, in order to make efforts to reach out to those requesters so they would not send basically violations of anti-boycott regulation requests to U.S. parties, because we're not going to process them. And it's a reportable requirement. So with this strengthening anti-boycott reporting and compliance memoranda, the changes to the 621 were implemented immediately. So as of the 27th of July, if you were filing anything online, you had the new field. If you're filing anything through batch through the mail, because our reports are due quarterly as a minimum standard, then you had to use the new form. Now, obviously, with the effect of the Hamas incursion into Israel, there was a lot of concern on whether or not there would be increased boycott language. And on the 19th of October, BIS released a FAQ concerning exports to Israel. And in this, there was absolutely no mention of anti-boycott regulations. I just put it on here because I wanted people to understand that while we are watching trade in the world after Israel-Hamas went to war, for all practical purposes, we haven't seen anything officially from BIS about things to look out for or concerns that they have had. So, next slide, please. And I know I'm going quickly, but there'll be time for questions afterwards, I promise. Okay. In the beginning of this year, on the 16th of January, Mr. Axelrod was here in New York at the Program on Corporate Compliance Enforcement at the NYU School of Law. I actually had the pleasure of attending this session and meeting him. He gave us an update on the voluntary self-disclosures, not only for export, but also for anti-boycott. And he talked more about this concept of exceptional cooperation. He suggested that a voluntary self-disclosure could go up to 50% reduction in the penalties. But the biggest thing that he said that night was that failure to file a voluntary self-disclosure is now considered an aggravating factor. So if you file, you get the benefit of filing. If you do not file, you are making your situation worse. There is no more neutral ground. And a lot of the lawyers in the room at that particular time were talking about maybe updating their considerations on whether or not to file a voluntary self-disclosure for both export and anti-boycott violations. He did not quantify the effect of the aggregating factor. That's not their job. They're not going to give us like, oh, well, if you fail to file a voluntary self-disclosure, it's going to double the penalties. They're not going to say that. He did reinforce the fact that the disclosure concerning the operations of others or the conduct of others is on a first come basis, so that if someone else reports you prior to you filing a voluntary self-disclosure, they will get the credit as an exceptional cooperator, and you will not get the credit for filing a voluntary self-disclosure. So this was sort of their setup. They talked about the fast track. They talked about the ability that if you are going to do a voluntary self-disclosure, you don't need to have all of the facts when you file. You can file a notice that you are going to prepare additional information. You're going to conduct a look back, whatever. But it's important that with this sort of first come mentality that if you're going to file a voluntary self-disclosure, do it as quickly as possible. And you can do the notice without all the facts. You can tell them that you believe that there were violations. You don't have to say it specifically during this time frame that may have been related to reporting or may be related to furnishing information. And you have to give specifics with your notice that you're going to file a voluntary self-disclosure. And so to make life easier, they also put together a web page for filing voluntary self-disclosures, which he announced that evening. and things were quiet. We understand that they're working on some more cases on the enforcement actions. And then we come up to a week and a half ago or so, which was the annual BIS update conference on export controls and policy. Now, at this conference, Mr. Axelrod had a lengthy presentation where they were talking mostly about export controls. But he also went into the anti-boycott enforcements that have gone on in the past 18 months or so. He talked about the voluntary self-disclosure guidance that had been put forward. He added that the individual violations can be bundled together. So you can do one notice of a voluntary self-disclosure, not individual notices for each violation. And he said that as they have been collecting the requestors since the 26th of July, they have put together a list for the first time of known boycott requesters. And this list was released on the 28th of March. It's available on the OAC website. We basically call it the requester list. And the first version of this is those parties that had boycott language requested by them or on their behalf in the fourth quarter of 2023. The list is interesting. There's the name of the company and a country. So one of the things that I can look at now is the origin of the boycott language. Where is it coming from? Now, there could be a one-off coming from Japan, but we do see lots of boycott language coming from Bangladesh and Pakistan, and what we see in our trade finance department these days. They also released a new version of Don't Let This Happen to You, which I saw in 2019. They updated it in 2022, early 2022, and they've updated it again. And so this compendium of cases that the BIS has put together does cover some anti-boycott matters. And they put that together, updated it. It's on the website, and we'll give you those links, and it's worth the read. On a related matter, they put forward a new freight forwarder guidance and best practices document that, while focused on export, also talks about the anti-boycott regulations and how they apply to freight forwarders. So if that's something that is of interest to you, please go to the BIS website and pull that down. Okay, next slide, please. All right, as I mentioned, the BIS is updating, or many government agencies are updating their websites. So the new website is simply bis.gov, but it's hard to find the press releases and some of the other historical information. So the old website is still active, which is bis.doc.gov with the index dash, it's index-php. We'll correct that. And you can access that website today. The Office of Anti-Boycott Compliance website has also been updated. And so the new one is www.bis.gov/OAC. But they don't have everything there yet. And so for looking at, say, these enforcement actions, you'll need to go to the old website, which is under the Office of Export Enforcement. So it's bis.doc.gov/index-php/enforcement/OAC. You see them on screen. We'll put them, they're in the deck. And Alex, I think we should be able to post this deck for everyone. If you go to the Office of Anti-Boycott Compliance, they still have the training videos. They still have example language. They still have all of the violations going back a few years. They don't have the John Hopkins case still on there, which is a very interesting case. We can talk about that in a separate session, but it's useful to check out that website while you still can. Next slide, please. Okay, enforcement actions. As I said, the first enforcement action under these new guidelines was against a foreign affiliate of a U.S. person, which is Rugeriis Beloit FSZ out of Dubai, part of Regal Beloit America. And this was in May of 2023. So the fine was minimal in, say, the export world or FCPA, or got no sanctions. It was only $283,000 or $283,500 for 84 violations, and that was voluntary self-disclosed. So obviously, it could have been a lot worse for them. These violations all were dealing with a Saudi customer that asked them to refrain from importing Israeli origin goods, right? So you'll see this in a lot of trade documents, goods of Israeli origin prohibited. Okay, not permittable is reportable. And that's one of the things that I've been stressing in conferences and chats like this one. We know people do not adhere to the request for boycott, but there is a reporting requirement under 15 CFR 760.5 or EAR Part 760.5, where any requests for this type of a boycott language, and a request is in broad sense, any notice receiving things like, Israeli blacklisted vessels prohibited, obviously. Ability to enter airports, right? We've seen these types of things. And even though you don't process those documents or you don't adhere to the requests for the birthplace of the country manager, they're still reportable. And that's one of the things I've seen from other institutions where not everything necessarily is being reported in broad senses. No one has said that they violated it, obviously, but it's something where we need to reinforce the reportability. Okay, so these 84 violations for September 2017 through September 2021. And obviously it was a failure to report. And still it was $283,500, which is unusual in the anti-boycott space back when violations used to have a penalty of $11,000. We'll jump to July 2023. B.E. Myers and Profence LLC were each fined in connection to a 2019 trade show in Bahrain. For shipping the trade show materials, they furnished information about the business relationships with boycotted countries or blacklisted persons, and they failed to report those requests. So the goods at the trade show furnished to its freight forwarder a commercial invoice / packing list, certifying that the goods were not of Israeli origin and not manufactured by a company on the Israeli boycott blacklist, right? Obviously, these are very well-known conditions that you cannot process, and they did not remove that language. And so they furnished the information. They did not report it, and each of these companies was charged about $48,000, $45,000 for 3-4 violations, and all in relation to that one trade show. These two were voluntary self-disclosed violations. Now we'll get to Pratt & Whitney, September 2023. Obviously a large company, well-known out of Michigan. They paid a $49,000 penalty for 13 violations of failure to report. So they had 13 requests from Qatar Airways to refrain from importing Israeli origin goods. That was in fulfillment of the purchase orders from the Qatar Airways for the Pratt & Whitney parts. So Pratt & Whitney did not, officially Pratt & Whitney Component Solutions, PWCS, did not report those 13 requests from Qatar Air. And they ended up self-disclosing, and they had a $49,000 fine. That brings us to Forta. Forta had 3 violations, which they did self-disclose. They were written up by the BIS, Office of Export Enforcement, for taking the remedial measures after discovering the conduct. So between their voluntary self-disclosure, their full cooperation with the BIS and OAC, and the remedial measures that they informed the BIS that they had taken, they quote unquote received a significant reduction in penalty. We do not know what the reduction was. This was, surprising enough, another trade show, but this time was in Abu Dhabi. The shipments of products and items for display. A freight forwarder received a commercial invoice certifying that the goods were not of Israeli origin and not manufactured by a company on the Israeli boycott blacklist. Once again, not permissible, must be reported. So, and then most recently, end of January, Wabtec Corporation was fined $153,175 to resolve 43 violations that happened between February 2018 and July 2022, where Wabtec received a request from a customer in Pakistan to refrain from importing Israeli origin goods in fulfillment of his orders. Wabtec did not report those 43 requests. And so they paid a penalty of $153,175 after they self-disclosed that they had these particular requests. So you can see the OAC is or the Office of Export Enforcement and the entire BIS is very focused on their BIS policies and the provisions within those policies for export exceptional cooperation. And the since January, the aggravating factor if you fail to file a voluntary self-disclosure. Most of these fines were based upon failure to report, right? If they did actually have an invoice that said no goods of Israeli origin, that's one thing, but they did not report that. And for those that have done the 621P reporting, you know you can put on there whether or not you have conducted the transaction, or you have conducted the transaction in an altered state, or that you have not conducted the transaction. They've reinforced the voluntary self-disclosure through the past 5-6 enforcement actions. They have reinforced the reporting requirement. So next slide, please. And I know that we're running out of time. I was trying to do this quick. Okay, so earlier this year, there's an amendment to the anti-boycott regulations called the IGO Anti-Boycott with a hyphen Act, HR 316. Now, this is simply a very small bill that updates the requirements and the scope. So 50 U.S.C. 4841 is the policy statement, and 50 U.S.C. 4842, apologies for the typo, are the requirements, which are then translated into the EAR Part 760. And the act is very simple. It says rather than unsanctioned foreign boycotts from foreign countries, it is also unsanctioned boycotts from foreign countries and international governmental organizations, or IGOs. But there's an extra bonus to this particular bill, which might be very beneficial to us in compliance. If passed, it would require an annual report to Congress, much like the INCSR, that would include a list of those foreign countries and IGOs that foster or impose boycotts, and a description of what they're boycotting and those boycotts themselves. This could be a very, very interesting artifact for compliance. So it passed the House back on the 13th of February. It has not come up for a vote in the Senate. I don't know exactly its current status, and we have 1 minute left of the time. I'm available to go longer if you guys are. So let's go next slide and see if there's any questions.
Thanks, James. To everyone who has no worries. That was a really good update that we needed, because so many changes occurred in the past few months. We should receive comments coming in through LinkedIn Live, and then they would be visible to us in the comment section here a couple of seconds later. So to all of you who have some questions, please submit them. Didn't
So
see any
Alex, I put
comments.
all the I have all the
Yeah.
links in the slides. They're just in the notes section. Can we send this out to the participants or post it somewhere for them?
Yeah. Is it possible to attach a file in the comments of LinkedIn? For those of you who want the slides, please send me an email or shoot me a text on LinkedIn, and I can share it as an attachment, because I don't think that LinkedIn allows attachments in the comments section. If we move to the last slide, I would just like to announce a couple of upcoming webinars that we have, not only for ACSS members, but for everyone. So on the 18th of April, we have an upcoming webinar for ACSS members only, Know Your Products to Avoid Export Violations, in which we go through the different ways you can classify your products and your items. On the 25th of April, we have a free webinar on the Russian tanker ghost fleet. And then a week later, on the 2nd of May, we will discuss core pillars of sanctions compliance training. So please visit our website for the upcoming training and events that we have for you, not only for ACSS members, but some free webinars as well. Thank you very much, James, for your update. Thanks, everyone, for joining us. I think we just had over 60 people joining us today. I hope our update helped you to get up to date with the latest anti-boycott regulations. I wish everyone a great day. See you soon.
Take care.
Thanks, James.